with the law school, the Bar Council of India mandates particular courses, particular core courses which are procedural and also like contract law or crimes law or procedural aspects which are essential for your law degree. But you can go above and beyond that. And that the freedom which you really get is with the electives. And we there are around 200 electives which are floated because the number is so vast, and these span everywhere. You study all sorts of subjects which are of interest to you. Now this was my fifth year in the university, so I've sort of exhausted the courses which are of interest to me, which is why we do these lectures, which is why it's a continuous engagement which we have with
Lovely.
with different professors who talk about this. Let me also acknowledge Megha, who's a board member and has assisted me in the lecture series last semester and also this semester. Megha.
Yes, thank you so much, Ankit. Hello, everyone. Hello, Professor. So nice to have you here. And on behalf of the society, as Ankit said, we're so happy that you could make time to be here today with us. Ankit's done a great job of covering everything that we do. And as the years pass, we also hope to eventually do more and more and get involved more and more. But yes, as of now, we are trying to just sort of make do with everything that we have, especially in the pandemic. And yes, we would love to also collaborate. I was listening to your prior conversations, and we would love to set something up as soon as this gets over. Anyways, thank you so much. Very nice to see your students here as well. And yeah, we look forward to this session. Thanks, Ankit.
Thank you so much.
Professor Popovski is here.
Yes,
So,
thank you very much, Professor Sergey Sayapin. Very pleased to have you with us. I'm teaching a course, Law and Practice of the United Nations, and we had several excellent collaborations already with law schools all around the world, let's put it this way, in organizing the Gender of Society, as you may probably have already heard from Ankit and Megha. And we are very, very privileged. In fact, I noticed that a lot of what I have been doing kind of correspond to what you have been doing. I was studying international law in the Moscow Institute for International Affairs, the famous GIMO, back in 1980s. And then I worked as a diplomat first. I was in the Embassy of London when I did my PhD at King's College Law School in London. And after that, I came back to Moscow as a European Union delegate for a human rights project in what they used to call Commonwealth of Independent States, the TASIS project, Technical Assistance to Commonwealth of Independent States, traveling all around Russia and opening legal clinics for law students to engage directly with complaints, with human rights violations, sometimes filing cases in the European Court for Human Rights. I remember the team back then in early 2000, 2002, filing the famous Kalashnikov case, which set a precedent of considering the prison conditions as amounting to degrading treatment under Article 3 of the Convention and many other cases. And so for that matter, what happened between ICRC and the Regional University almost 2 days ago, we have already the news announcement that we are going to jointly offer a course on international humanitarian law and international criminal law. So it comes very timely. We didn't plan it, but it happened to be so timely to have you with us today and to discuss apparently an interesting question about Central Asia, international law, human rights, and how, let's say, the European experience, the European Convention, the European Court of Human Rights, and other human rights mechanisms, and not only the European, but United Nations, maybe generally, and the ICRC fit in the context of Central Asia. Let me give you also one interesting kind of anecdote. When I worked for the United Nations University in Tokyo, I was invited to organize summer schools in various parts of the world, and we cooperated with the university in Dushanbe in Tajikistan, the Tajik State University. And kind of extraordinarily, we found a good cooperation there, even if the topic was human rights. It was announced as a human rights summer school delivered by various professors all around the world, famous Elizabeth, what's her name? The one from Essex. She came also, and some others. No, sorry,
Françoise Hampson. She was my professor at Essex.
Françoise Hampson at Essex. She came to explain the European cases. And Bill, maybe you know Bill Bowring, a Russian speaker, by the way. Bill Bowring, also based in the college in London. He also came to Tajikistan. And only later I found out that, in fact, the way to this happened at all in Tajikistan was that the rector of the university, a senior person, who knew very well the president of Tajikistan, actually asked for a permission. And they were good friends anyway for a long time. And there was no problem even for the president of Tajikistan to agree for a human rights summer school to happen in Tajikistan, in his own capital. We were treated very well. We were taken in nice restaurants all around the country. And for me, that was but somehow to give also the opposite perspective here, in the discussions we had later, I didn't know that. I found out that when Tajikistan joined the European Convention of Human Rights, and accordingly it had to comply with the Protocol 6, the elimination of the death penalty, which was a requirement to join the Council of Europe and the Convention. What happened in Tajikistan was, yes, they applied the abolition of the death penalty, but before that they basically executed everybody on the death row. So that was the sad anecdote from my experience in Tajikistan. But anyway, that's all from me. I wouldn't take a minute of more time. My big pleasure to meet you, Sergey, and to welcome you to our society and our law school. I'm sure KIMEP, by the way, for the students to know, this is one of the most prestigious universities, not only in Kazakhstan, but in Asia. So maybe Sergey will tell more about KIMEP. It's an excellent. I haven't been there, but I've had a lot of communications with faculties from KIMEP Law School, maybe top university in Central Asia, if not more. And I encourage my students also to join the possible collaboration between Jindal Law School and KIMEP Law School in the future. Briefly, Sergey Sayapin has been with ICRC between 2000 and 2014 as a regional director for Central Asia, I'm sure with a lot of experience. So we can ask him later to tell us a bit more from that experience after the actual lecture on the topic of Central Asian approach to human rights. And after that, he has been a professor with the law school in KIMEP, teaching international humanitarian law, human rights, and other subjects. Our big honor and privilege to have Sergey with us. Although we don't know each other before, I'm very happy to continue this collaboration, to invite you to India once the travel becomes possible, to have you physically on campus, to see our achievement over there. Maybe you've heard of Jindal already. It's #1 university, a private law school in India, but also I think we scored already in the top 70 law schools in the world. And being a young, only 12 years old law school, this is already a significant achievement. As KIMEP is, by the way, KIMEP is not much older, but also a top law school in the world. So we can collaborate a lot. And thank you, Ankit, by the way, for making this meeting possible today. Okay, Sergey, your time starts now. Thank you again.
So just to hello, Professor Sergey. I'm Professor Abhinav Malhotra. I'm co-instructor with Professor Popovski. So I'm really looking forward to your lecture because me and Professor Popovski are trying to work something on mechanism of human rights for Asia. So it's something which I'm very excited to listen to, and thank you to the General Society for organizing this lecture. So thank you.
Thank you very much, dear colleagues, for inviting me to speak to you today. Thank you very much for this generous introduction. And let me repeat what I said a few minutes ago. I would be delighted if our students could cooperate with yours, and also if we could establish a more regular collaboration between our institutions. Indeed, the School of Law at KIMEP University is the smallest law school in the country, but nonetheless we are ranking very highly in Kazakhstan, in Central Asia, and we are looking forward to expanding our international collaborations. And I hope this will be the beginning of such a fruitful and very, very important collaboration. Dear colleagues, ladies and gentlemen, I'm honored to address you today. Let me thank Jindal Global Law School and Jindal Society of International Law wholeheartedly for this honoring invitation. I'm particularly thankful to Professor Veselin Popovski for his introductory comments and to Mr. Ankit Malhotra for his support in organizing this lecture. Thank you very much, dear colleagues. Let me start with a few disclaimers. First, I am going to discuss a few ideas pertaining to the action of humanitarian and human rights institutions in Asia, but it's certainly understood that the discussion, however comprehensive it may be, will not be complete. Asia is an incredibly diverse region, hosting 49 countries, including the largest country in the world, Russia. Among the world's 20 most populous nations are Asian. Just think about it. 4 of the world's 5 most populated countries are in Asia: China, India, Indonesia, and Pakistan. As of September 2021, Asia's population amounts to 59.76% of the world's total population. Asia is home to all of the world's major religions and all major legal systems. Given the economic potential and political influence of this region, I'm prepared to take Parag Khanna's argument underlying his famous book even further and claim that not only the future is Asian, but the present already is Asian. And given Asia's size and diversity, I cannot claim that my talk will include all aspects which are potentially relevant. I will do my best to offer some rather general observations, but I am not claiming to offer ready answers to all questions. Instead, I hope to raise some questions for discussion, some of which might be answered not today, but in the years to come. And of course, I will be grateful for your helpful observations and suggestions. Next, I am based in Central Asia, and my understanding of the topic is inevitably informed by Central Asian perspectives. As you will see, I will give you examples from my region and compare to a reasonable extent the Central Asian experiences with those from other places. But I understand that humanitarian or human rights action should be contextualized and suited to the realities of each and every country. I'm now thinking of November 2003, almost 18 years ago, when a new international colleague joined us at the ICRC Regional Delegation in Central Asia, where I was working at the time. That colleague was from Latin America, where the ICRC was running a successful educational program on international humanitarian law. And the colleague was determined to apply the Latin American experience in Central Asia. It took us literally a few months to convince her that it would not work, at least not to the desired extent, because the Central Asian states' educational systems were different from those in Latin America and could not as such be adapted to the ICRC program. Instead, the ICRC program should have adapted itself to local laws and policies, which it did, and worked quite successfully for more than 10 years after that. Indeed, the ICRC has always been very good throughout its history at adapting itself to realities on the ground. And indeed, it is this operational adaptability and flexibility which make the ICRC so successful in what it does. And finally, it's understood that I will focus on international humanitarian and human rights institutions and not on domestic ones. No one doubts the role and significance of national institutions, such as, for example, interdepartmental commissions on human rights or humanitarian law, or relevant non-governmental organizations. However, they are too numerous and diverse to attempt discussing them within a single presentation. Instead, I'll focus on a few international and regional mechanisms which may contribute to improving the quality of humanitarian and human rights action in Asia. And I'll be more than happy if some of my reflections are useful. Having said this, let me please proceed to the substance of my talk. I will start by discussing some of the main trends in the regional human rights protection in Asia. The key questions there will be the absence of a regional human rights court in Asia and the feasibility of alternative institutional mechanisms. I will then proceed to talking about the prominent role of the International Committee of the Red Cross in some Asian contexts, and about the ICRC's evolving attitude with respect to international human rights law. Next, I will say a few words about the role of international criminal justice institutions in the safeguarding of human rights in Asia. And then I will conclude by offering a few policy recommendations. Obviously, Asia does not have a regional human rights court like those in Europe, the Americas, or Africa. I think it will be fantastic to have one, but reasons for not having such a court must be really complex. They must be more complex than, for example, simply the number of countries in Asia. The Council of Europe now has 47 members, just 2 states fewer than there are states in Asia. On the other hand, the African Union now has 55 member states, more than Asia has. I believe the linguistic diversity is not a reason for not having an Asian human rights court either. According to some estimates, Asia is home to about 2,300 languages. However, for comparison, the situation in Africa is not significantly easier in linguistic terms. Africa has about 2,000 languages, and yet this was not in itself an obstacle to the establishment of the African Court on Human and People's Rights. Rule 27 of the court's current rules of procedure lays down that the court's official languages include Arabic, English, French, Portuguese, Spanish, Kiswahili, and any other African language. And the working languages are Arabic, English, French, and Portuguese. If there were an Asian human rights court, the linguistic issue could be solved, for example, by making the major Asian languages plus a few European languages the working languages of the court. This is not a major issue. Actually, languages such as Arabic, Bahasa Malay, Chinese, English, Hindi, Persian, and Russian might serve as unifying and not divisive factors. The real obstacles to the establishment of an Asian human rights court appear to include political, ideological, and legal differences between Asian states, and these are more difficult to overcome. In Europe, the Americas, and even Africa, there seems to be more common ground for building regional institutions, including for the protection of human rights, than there is in Asia. Especially in Europe and Latin America, such common ground includes the Christian religion and the continental legal systems. In turn, Africa has experienced pagan, Christian, and Islamic influences in terms of religion and has Islamic, common law, civil law, and traditional legal systems. But Asia's political and legal map is even more complex than that. I claim that religion and political ideology are 2 factors exercising decisive influences upon a state's attitudes towards human rights. If I am right, and please feel free to tell me if you think I am wrong, then it would be quite utopian to hope for the establishment of a single human rights court that would be acceptable at the same time, for example, to Arab states, China, India, Iran, Israel, the states of Central Asia, and especially North and South Korea. If the court were ever established as an experiment, it would be a massive and heavy bureaucratic machine, difficult to operate and even reach out to geographically. Where would the court be based? Would it be in Istanbul, in Dubai, in New Delhi, in Beijing, Singapore, Tokyo, anywhere else? I think that answers to such questions are so difficult that it's no wonder that the court has not been established yet. Actually, there is one way to establish an Asian human rights court, if this utopian project were ever to materialize. A single human rights court for Asia might work if it were composed of several chambers, for example, for Muslim states, except the Arab states, and I will explain in a few moments why the Arab states might not be interested in this initiative anymore, for the Far East and for Central Asia. And these chambers would be based in the respective sub-regions. Obviously, members of such sub-regional groups might more easily agree on mutually acceptable approaches to the organization and operation of their respective chambers. Likewise, such chambers would be more easily accessible to individuals from the respective sub-regions. Each chamber could be modeled after the current setup of the European Court of Human Rights, that is, without the intermediary of a commission, or with a commission tasked with the preliminary consideration of applications, like in the Americas or in Africa. Alternatively, other sub-regional enforcement mechanisms could be put in place, and I will now turn to possible alternatives. In order to see what could be done to improve the human rights enforcement machinery in Asia, let us briefly consider what already is in place, what the relative advantages and disadvantages of the existing mechanisms are, and then discuss at some length how those mechanisms could be reinforced without the formal establishment of an Asian human rights court. I suppose that this course of action would be easier, cheaper, and quicker. The Arab states already have an Arab Charter on human rights based on Islamic law. Its first edition was adopted already in 1994, but did not enter into force. A subsequent edition of the Charter was adopted 10 years later, in 2004, and was more successful in that it entered into force on the 15th of March 2008. Article 45 of the revised Charter established an Arab Human Rights Committee consisting of 7 members who must be highly experienced and competent in the committee's field of work. In accordance with Article 48 of the Charter, the committee considers state reports which are to be submitted within a year of the Charter entering into force for a state party, and then periodic reports must be submitted every 3 years. The committee also submits annual reports to the Arab League and has the authority to interpret the Charter. Overall, the Arab Human Rights Committee has been modeled after the ICCPR Human Rights Committee, and although it currently lacks competence to receive individual communications, it does represent an important step. In 2014, the Statute of the Arab Court of Human Rights was adopted, but it needs 7 ratifications to enter into force. The statute has been criticized by some Western commentators for not permitting individual access to the court and restricting it to states and accredited NGOs only. However, it should be recalled that the Regional Human Rights Court in Europe and the Americas had similar histories, and the Arab Court of Human Rights might, over time, also be transformed into an institution receiving individual communications. For the time being, though, it may be assumed that Arab nations would not be interested in a big Asian human rights court anymore, since they are already constructing their sub-regional human rights system. Let us now fly to the geographically opposite part of Asia and see what the Association of Southeast Asian Nations, ASEAN, does for the promotion and protection of human rights. Indeed, as Professor Rona Smith observes, ASEAN's focus is on the promotion rather than protection of human rights. The ASEAN Charter was adopted in November 2007 and entered into force in December 2008. In 2012, the ASEAN member states adopted a declaration on human rights. This declaration received mixed reviews given the perceived low-impact compliance opportunities. This is largely due to the absence of an individual communication mechanism, which follows from ASEAN's commitment to the principle of non-interference in the internal affairs of member states. Instead, ASEAN established an intergovernmental commission on human rights, which periodically examines issues of common concern to governments such as migration and labor issues. And now what about Central Asia? 30 years after the dissolution of the Soviet Union, the Central Asian states are still learning to apply international human rights law and to communicate about it with external and internal audiences. Most recently, the COVID-19 pandemic exposed numerous practical human rights issues in Central Asia, and not only with respect to healthcare as such. Access to information was not always consistent. Statistical methods employed were at times contradictory. The legal status of regulations issued by the chief sanitary doctors was uncertain, and the legal challenges posed by the state of emergency regime were plentiful. The transfer of education online was not a satisfactory solution in terms of quality for families with many children, where there is not enough hardware to let children attend classes simultaneously. Defense lawyers reported that online, civil, but especially administrative and criminal trials via WhatsApp were not a good solution either, among other things, due to the limited number of participants in a session and difficulties related to the examination of evidence. The consequences of these ad hoc solutions are yet to be seen, but there are also useful lessons to be learned. In 1995, the post-Soviet states, as members of the Commonwealth of Independent States, CIS, adopted a Convention on Human Rights and Fundamental Freedoms, which included, along with civil and political rights, a broad catalogue of economic and social rights. In 1993, so 2 years earlier, the CIS established a Human Rights Commission with a mandate to consider interstate communications as well as communications from individuals and NGOs. However, the Commission is not very active as a matter of practice. Some post-Soviet states have also accepted the jurisdiction of the European Court of Human Rights, and the impact of its case law in the relevant domestic legal systems is much more prominent than the post-Soviet human rights commissions. In Central Asia, at least Kazakhstan could theoretically join the Council of Europe because a part of its territory is geographically in Europe, but apparently this is not a priority. I believe that the Central Asian states should invest, as a matter of urgency, in the digitalization of administrative procedures and other state services. Doing so will increase the efficiency and speed of such procedures, significantly reduce corruption risks, and visibly improve the quality of dialogue between governments and civil society. Instead of introducing new rules, regulatory barriers should be taken down wherever possible, especially in the field of economy. Greater transparency and accountability should be achieved in political decision-making. As a result of such reforms, economic and political systems will be modernized and the quality of life will grow. However, the political tradition in Central Asia, and probably throughout most of Asia as such, is such that workable reforms will only originate at the top of the political systems. This means that governments should realize that compliance with international human rights law is not harmful to the state, and will, in the language of Uzbekistan's new human rights strategy, contribute to, I quote, further strengthening the country's authority in the international arena, in particular to improving the position of the state in economic, political, and legal rankings and indices. End of quote. The authorities of Central Asian states should realize that international human rights are closely linked with all areas of life, and respect for human rights is an important indicator both for international investors and policymakers, for it testifies to the stability, predictability, and trustworthiness of a state's judiciary and law enforcement system. Judges, and especially those dealing with criminal and administrative cases, and law enforcement officials should be trained on the application of domestic and international human rights law, and states should genuinely align their law enforcement practices with their obligations under applicable human rights instruments. Importantly, international human rights treaties and constitutional provisions on human rights should be made directly applicable in domestic legal systems. Resolute measures must be taken to combat torture and other forms of ill treatment. The legal status and influence of national human rights institutions should be elevated, and they should be staffed by individuals with professional knowledge of international human rights law, international humanitarian law, and international criminal law. Regular dialogue with the United Nations human rights organs, international and domestic human rights NGOs will be helpful. I am sure that the cumulative effect of all such measures will benefit individuals, society, and states alike. I think in particular that a Central Asian chamber of a big Asian human rights court, or even better, a sub-regional Central Asian court of human rights would be useful. The idea of a Central Asian Union, a regional organization for Central Asia, has been in the air for a few years now, and if it ever materializes, the new integration project should most definitely provide for a Central Asian human rights mechanism. Dear colleagues, if you have questions about human rights developments in Central Asia, I'll be glad to address them in the Q&A part. And now I will, with your permission, proceed to discussing the evolving role of the International Committee of the Red Cross. I joined the ICRC in September 2000 and worked there until 2014. And the institution has changed quite a lot over those years. I joined the ICRC after getting an LLM in international human rights law from the University of Essex in the UK, and it took me some time to get used to my first boss at the ICRC repeatedly telling me not even to mention human rights in public, so that the ICRC would not be confused with human rights organizations. In my early years at the ICRC, quite a few things would surprise me. For example, among international colleagues visiting places of detention in Uzbekistan, there was a mathematician, a former musician, and even an opera singer. All of them lovely people, but I could not grasp the utility of their skills for the purpose of the ICRC humanitarian work. I could understand why the ICRC teams would include medical doctors specializing in torture or psychologists, but not people of those more exotic professions. Perhaps I was not wise enough to understand this. But then things suddenly started changing. That colleague from Latin America, whom I mentioned at the very beginning of my talk, ended her mission at our education department and was appointed as a legal advisor to the protection department. One of the first things she did in her new position was to invite a local professor of criminal procedure and penitentiary law to give her colleagues at the protection department a practical understanding of those subjects. I think it was a fantastic thing to do for people, many of whom were young and had a very limited understanding of Central Asia. And none of them except her was a lawyer. Furthermore, it would have been very useful to make such introductory courses regular. However, her mission ended after a few months and the course has not happened again. The changes I started noticing at the delegation in Tashkent were not accidental. They meant that the ICRC started changing at the global level. For example, the ICRC started appointing to positions of authority qualified individuals in the Western world. I believe that this new approach helped the International Committee of the Red Cross to become truly more international and also more professional. But there was also another reform which was really groundbreaking because it affected the very core of the ICRC humanitarian action and its public image. I mean the ICRC's institutional decision to make some limited use of international human rights law in order to improve the quality of protection and assistance which it renders to victims of armed conflicts and other situations of violence. This decision was made in 2006 when the ICRC adopted a comprehensive doctrine entitled The Invocation of International Human Rights Law by the International Committee of the Red Cross. The new approach should have enabled the ICRC, I quote, to use human rights where appropriate in its humanitarian work, while ensuring that it remains distinct from doing human rights advocacy, thereby maintaining the ICRC's unique identity. End of quote. It is understood that under this approach, the ICRC still has no legal or institutional responsibility to invoke human rights law or to work for its faithful application. Accordingly, the ICRC may decide not to refer expressly to any rule of human rights law when it considers that such invocation would harm its operational activities and ultimately the persons whom it strives to assist or to protect. In such cases, the ICRC would prefer to use more general expressions, such as the principles of humanity or internationally recognized standards. However, in any event, after that, my first boss at the ICRC would not be able to tell me not to speak of international human rights law anymore, and I think it's better so. Let me now say a few words about the substantive rights which the ICRC may now address in its humanitarian action. You will notice that these are mainly the so-called non-derogable rights. They are fundamental to the preservation of human life and dignity, and as such, they are a key part of the ICRC humanitarian mission. The first substantive right is the right to non-discrimination. The ICRC believes that this right is integral to the fulfillment of other human rights, and as such underlies all other humanitarian guarantees. Next, armed conflicts threaten, first and foremost, the right to life. The lives and health of persons are threatened by indiscriminate attacks, unlawful use of weapons, summary executions, deprivation of medical care, not to mention less controllable dangers such as communicable diseases or natural disasters. The prohibition of torture or other forms of cruel, inhuman or degrading treatment or punishment is another fundamental human right. In line with applicable international law, the ICRC's position is clear. It firmly rejects any recourse to torture and other forms of ill treatment. The ICRC also works to prevent particular forms of ill treatment, such as mutilation, unlawful medical or scientific experiments, and rape and other forms of sexual violence. Finally, the ICRC may invoke the principle of non-refoulement, which consists in the prohibition of transferring a person to a place where he or she risks facing torture or another form of ill treatment. Next, as part of its visits to prisoner of war camps, civilian internment camps, and places of detention, the ICRC monitors conditions of detention and, where necessary, makes recommendations as to their improvement. Slavery and forced labor are prohibited by human rights law. Under all major human rights law regimes, the prohibition of slavery is non-derogable and may not ever be suspended. In the context of international humanitarian law, the prohibition of slavery and forced labor is pertinent in at least two respects, as concerns the labor of prisoners of war and civilians, and the crime of sexual slavery. In 2013, the ICRC observed in a statement addressed to the Third Committee of the United Nations General Assembly that, I quote, "The ICRC strives to respond to sexual violence in armed conflict and other situations of violence in a multidisciplinary manner. It provides medical and psychological care and economic support to victims, engages in activities to minimize risks, and works to prevent sexual violence." End of quote. With respect to the recruitment of children into armed forces, the ICRC, and I quote again, places a great deal of emphasis on prevention. The ICRC will continue to promote the principle of not recruiting children and support the development and application of international humanitarian law at field level, in the hope that one day there will be no more child soldiers and that humanity and justice will prevail. End of quote. In extreme circumstances of an armed conflict, it's very important that there be a framework for a competent and, to the extent possible, impartial judicial revision of decisions, and that persons protected under international humanitarian law have a chance to have their case heard and arguments taken into account by the authorities in whose power they find themselves. The ICRC attaches particular importance to two aspects of the due process of law: the possibility of judicial revision of grounds for detention, and respect for judicial and other procedural guarantees. Next, the ICRC is strongly committed to working together with its partners in the International Red Cross and Red Crescent movement for the sake of reuniting family members separated by armed conflicts and other situations of violence. A common violation in such situations is the crime of enforced disappearance. The ICRC considers enforced disappearance a crime under international law and endeavors to prevent its occurrence. Unlike most human rights provisions analyzed above, rules on the freedom of movement are not non-derogable and may be restricted in times of public emergency. However, the substance of these human rights provisions is mirrored in humanitarian law, inasmuch as the prohibition of the deportation or transfer of civilians in international armed conflicts has long been considered a serious violation of the laws and customs of war. And in non-international armed conflicts, the displacement of the civilian population is prohibited. And last but not least, the ICRC recalls that private property enjoys protection as such and may not be confiscated, destroyed, or seized, except in situations of imperative military necessity. Whilst under human rights law, the right to own property is an economic right related to the welfare of an individual, humanitarian law protects property not so much as a matter of material wealth, but as a factor helping protected persons to survive. In circumstances where money nearly always loses its pre-conflict value, and the worth of food, water, medicines, clothing, and shelter, on the contrary, increases ever more as they become indispensable to the wounded, sick, and shipwrecked combatants, prisoners of war, and civilians. By this time, you may be asking yourselves why I am telling you all these things, except that they are academically interesting. I believe that this discussion is relevant to the current situation in at least 2 Asian states, and the ICRC could play an increasingly important role in those contexts in the years to come. Obviously, the first one is Afghanistan. Despite that the Taliban is now assuring everyone that its new rule will be more moderate than 20 years ago, there are good reasons to be concerned about the rights of women, non-Muslims, and other minority groups. Although Afghanistan ratified some key human rights treaties, including both international covenants in 1983, Convention Against Torture in 1987, Convention on the Rights of the Child in 1994, Convention on the Elimination of All Forms of Discrimination Against Women in 2003, and others, most optional protocols to those conventions relative to individual communication procedures have not been ratified. And 2 notable exceptions are the optional protocols to the Convention on the Rights of Persons with Disabilities, ratified in 2012, and to the Convention Against Torture, ratified in 2018. Given that the international human rights treaty body's capacity to act is very limited in these circumstances, I submit that the ICRC's role in securing the rights of the most vulnerable groups through bilateral and confidential dialogue will be important. The ICRC has been present on the ground in Afghanistan since 1987 and has working contacts with local and high-level leaders. Importantly, the ICRC works in close contact with the Afghan Red Crescent Society and has the trust of all parties to the conflict. What it does not have is enough money. In a statement of the 17th of August 2021, so just about a month ago, Robert Mardini, Director General of the ICRC, said that the ICRC had a funding shortfall of about $33 million out of a budget of approximately $86 million, so almost 50%, and appealed to donors for immediate additional funding to support the ICRC work, including in the medical field and at the physical rehabilitation centers. Hopefully, some of the outstanding funds will be collected soon. The second context is also very complex. There is no armed conflict there, but the situation is nonetheless quite alarming. I mean the reported situation of Muslims in Western China. In August 2018, the United Nations reported that at least 1 million Uyghurs had been detained in counter-extremism centers in China's Xinjiang province. The report also revealed that a further 2 million Uyghurs had been forced into so-called re-education camps for political and cultural indoctrination since 2017. In June 2021, so a couple of months ago, Amnesty International called these measures draconian and said they amounted to crimes against humanity. However, China has rejected the allegations, saying that its policies towards the Uyghurs and other Muslim minorities are necessary to fight extremism. According to the ICRC website, the ICRC Regional Delegation for East Asia covers China, North and South Korea, and Mongolia. The delegation was initially established in 1987 in Hong Kong, and from 1996 was based in Bangkok. In 2005, the delegation moved to Beijing. The website mentions that the delegation's main focus is to promote awareness and implementation of international humanitarian law. The delegation also aims to familiarize governments, experts, national Red Cross societies and civil society with the ICRC's humanitarian work and emergency response around the world. Joint ICRC and National Red Cross Society's physical rehabilitation projects in China and the Democratic People's Republic of Korea provide direct services to vulnerable groups. However, and this is important, we do not know whether the ICRC intends to visit some of those re-education camps in Western China in accordance with its own modalities. And I think the ICRC should at least attempt discussing this possibility with Chinese authorities. It will not be easy, it will be very difficult. However, actually, dialogue with the ICRC leading to possible humanitarian visits would be in China's own interest. If the stated goal of China's policy is to fight extremism, then individuals undergoing re-education might well qualify as security detainees in the language of the ICRC. The ICRC visits such detainees in many other countries of the world exclusively for humanitarian purposes. Both the dialogue leading to such visits and the visits themselves would be confidential, and the ICRC would not report its findings to the mass media or publish them otherwise. The ICRC recommendations would be transmitted directly to Chinese authorities, and the public would just know that so and so many humanitarian visits were carried out to so and so many facilities, and that's all. So by proposing and possibly carrying out such visits, the ICRC would exercise its strictly humanitarian mandate, and China, by giving a positive response to the ICRC initiative, would show its commitment to humanitarian principles. I think that only one other option would be better than this, if China itself invited the ICRC to visit. So let's see if any of these options is possible. And now let me proceed to the third substantive part of my talk. Although institutions of international criminal justice do not address human rights or humanitarian action directly, they certainly contribute to the promotion and protection of human rights by holding accountable individuals who commit crimes under international law, such as genocide, crimes against humanity, or war crimes. As a matter of fact, Asia was one of the birthplaces of international criminal law, in that it hosted the second international criminal trial in history, the Tokyo trial. Although that trial was imperfect by far, in procedural terms, and was persuasively criticized by Indian judge Radhabinod Pal for this, it certainly continues holding an important place in the history of international law. Subsequently, several hybrid criminal tribunals were established to try individuals for international crimes committed in a few other Asian contexts, in particular in Lebanon, East Timor, Cambodia, Bangladesh, and Iraq. And last but not least, quite a few Asian states supported the establishment of the International Criminal Court. I think it will be useful and interesting to take a critical look at some recent developments relative to institutions of international criminal justice in Asia, and to propose some ways forward. The Rome Statute of the International Criminal Court now has 19 states parties from the Asia-Pacific region, including Palestine, whose statehood is currently doubted by some states. If we recall that Asia consists of 49 states, 19 is not that many. And I think at least two observations are important in this regard. First, and this fact is well known, some of the leading Asian powers, such as China, India, Pakistan, Iran, or Israel, are not parties to the Rome Statute, which factor limits not only the court's territorial and personal jurisdiction, but also its influence and prestige, if you wish. Second, and I'll focus on the practical significance of this aspect in a few moments, the ICC statute has not been ratified by most Muslim states. I suppose because in their view, the statute does not sufficiently reflect Islamic international law. By the way, I will not be surprised if Afghanistan will soon denounce the statute for this very reason, but that's a different issue. What does matter for the purpose of our discussion now is that the International Criminal Court has no jurisdiction with respect to nationals of most Asian states, as well as some notable non-state actors such as ISIS. And I see one possible solution. I wrote in a blog post a few years ago that the ICC was not an appropriate judicial forum for dealing with ISIS crimes, in my humble opinion, and not only because the ICC had no territorial jurisdiction with respect to crimes committed in Iraq and Syria. None of them have ratified the statute. But because the substantive and procedural law of the ICC is not sufficiently compatible with Islamic international criminal law, due to the former's secular character. In the opinion of ISIS, which is an extremist Islamic actor, secular international criminal law is a product of Western civilization. Hence, holding ISIS members liable exclusively under secular international criminal law would not produce an appropriate ideological effect. It is crucial that leading Islamic scholars have expressed criticism against ISIS, and that quite a few Muslim states have issued declarations to condemn ISIS action. It means that ISIS not only represents an ideological minority in the Muslim world, but moreover, that this minority is profoundly wrong in its action from the point of view of Islamic religion and law. Among other things, leading Islamic scholars have reaffirmed that Christians and Yazidis, who were frequent victims of ISIS, are kitabi, people of the book, and no damage must be done to them. That Islam does not tolerate violence towards women and children. That Islam does not allow the reintroduction of slavery. That torture is prohibited, and the punishments for crimes should be imposed in the framework of a fair trial procedure based on justice and mercy. Now that ISIS crimes have been criticized by Islamic scholars on the basis of Islamic international criminal law, a further step could be made towards the establishment of a hybrid tribunal for ISIS, with due regard to the following 5 elements. First, the legal basis for such a hybrid tribunal should combine elements of secular international criminal law and procedure, in particular as far as the rights of victims and defendants are concerned, and of relevant substantive and procedural rules of Islamic international criminal law. Second, no less than 50% of the tribunal's judges prosecutors and defense lawyers must be scholars and practitioners of Islamic criminal law in order for the tribunal to be credible in the eyes of Islamic communities. And the other key vacancies could be filled by lawyers from other legal traditions. Third, the seat of the tribunal should ideally be in the Middle East, both for practical reasons, such as proximity to victims, witnesses and evidence, and symbolic ones. For example, the seat of the Nuremberg Tribunal was highly symbolic because it was in an important center of the defeated Nazism. And the tribunal adjudicating on the basis of Islamic law should not be too distant from the cradle of Islam. Fourth, it goes without saying that Arabic, Muslim sacred language and a predominant language in the Middle East or West Asia, if you prefer this geographical terminology, should be among the tribunal's official and working languages. And finally, the tribunal could be established on the basis of a treaty to be concluded by interested states, both within and outside Asia, or on the basis of a Security Council resolution, and could be co-financed by the United Nations and from contributions by interested states. Obviously, no efficient criminal prosecution of ISIS members will be possible until ISIS has been defeated militarily. But once this is done, the administration of justice for crimes committed in West Asia, one of the cradles of human civilization, should become an important factor for the international community. And when that happens, some of us who practice international criminal law in Asia and beyond will be called upon. And now, in conclusion, let me suggest a few policy recommendations based on my reflections. Here's probably the most important conclusion. Asian challenges demand Asian solutions. International experience is useful, but as I said earlier, the way things are done in Latin America may simply not be compatible with the legislation of Uzbekistan. If there is a problem, it must be understood and analyzed in a local context, and proposed solutions must be suited to that very local context. Since Asia is huge and diverse, a single human rights court for Asia is probably not feasible. The Arab states' effort to establish the Arab Court of Human Rights testifies to this, and the other Asian sub-regions will probably follow that example. The format of a human rights court is ideal from my perspective. Yet, where states decide not to create a court, a human rights committee with or without the power to consider individual communications could be established. In turn, where a committee does not seem feasible, at least a human rights commission with oversight functions could be put in place. The role of the International Committee of the Red Cross will remain important in Asia. The ICRC sometimes is the last and only international institution to stay in the most difficult contexts, and often embodies the only hope left to affected communities. It is now vital that the ICRC maintain dialogue with all stakeholders throughout Asia, so that the fundamental rights of people are respected. I also hope that the ICRC will continue internationalizing itself, including by employing qualified people from Asia. Let me encourage young colleagues who are listening to me now to apply for jobs at the ICRC in your own countries or abroad if you are motivated by humanitarian action. The ICRC will benefit from your expertise, and you will benefit from the opportunities offered by the ICRC. If you feel like discussing my own experience at the ICRC in more detail, please feel free to ask questions soon.
Thank you so much.
Criminal Court.
Sorry. Oh, go ahead. Sorry.
I'm almost finished. Just one more minute.
Go ahead.
The International Criminal Court is not very popular in Asia, and it's a fact that will hardly change anytime soon. 23 years since the adoption of the ICC statute in 1998 were enough time for the states of Asia to make up their minds with respect to the ICC, and the limited number of Asian states among the state parties to the ICC statute means just one thing. There's something normative, structural, or maybe cultural about the statute and the court that the states do not like. I suppose that Asia will see even more regional ad hoc alternatives to the ICC in the future, and some of you will contribute to those developments. And now, ladies and gentlemen, I'll do my best to address your questions and comments. Thank you very much for your kind attention.
Excellent. Thank you very much, Professor Sayapin. It was really a wonderful presentation and comprehensively covering not only human rights, but also international criminal law and international humanitarian law and other issues that are in the purview of the International Committee of the Red Cross. And beyond that, the appeal, what I found very attractive is this appeal for Asian countries to join forces and create regional bodies one way or another. They can learn from the experience, but also from the mistakes of other regions where human rights have been addressed, sometimes not so successfully, but nevertheless in a regional institutional manner. So somehow it is kind of a advantage to have the experience of the African Charter of the Organization of American States, of the European Convention of Human Rights, of ASEAN human rights mechanisms as a model, probably not as a model, but as experience to follow or to modify as to better address the specific issues which every continent or every region in the world has. Wonderful. I'm very much in agreement with all your suggestions here. That's the way to go. That's a gap to fill. I cannot agree more so with your final point, which is that even if the International Criminal Court, the global one, based on the Rome Statute of the International Criminal Court, doesn't work the way it was expected when the Rome Statute was adopted already 15 years ago, longer than that, actually, 20 years ago. How to go ahead with that? There are initiatives and also regional initiatives in Africa. There is an initiative maybe to create an African regional criminal court instead of having
under the Malabo Protocol.
Exactly. So there are possibilities, let's put it this way, to go ahead when the global organs do not satisfy the expectations. Absolutely in agreement with that. And as Abi Malhotra mentioned, my co-instructor for the course Law and Practice of the United Nations, we are thinking that way. We are considering how the European, in this case, perspectives, the practice of the European Convention, the European Court, and other European organs in the European Union has its own human rights mechanisms. How can this be modified to fit the Asian context? I agree with you. It's not only Central Asia. We can talk about Asia more broadly. We can also link with ASEAN, what ASEAN has been doing in the more recent times, not originally when ASEAN was created, but I will say in the last 20 years, we have also a good development of human rights mechanisms, not entirely the same as the European, Africans, and Americans, but nevertheless, I will say specific to the ASEAN regions. And these are also an excellent, I will say, experience to have in mind when creating further bodies. I'm happy to open. Ankit, you want to operate the answers and questions sessions? Please go ahead.
Well, let me begin by thanking Professor Sergey for the most enlightening discussion. It was quite enriching, and I think the viewpoints were quite measured in how you delivered them, and the deep insights that you offered were very thought provoking. I invite everyone to share their questions in the chat box or also ask them live. But just to get the ball rolling, let me just offer something which I came across whilst preparing for the lecture. There's this article which spoke about the topic which was delivered today, and it gave the example of the extraordinary chambers in the courts of Cambodia. Professor mentioned it in passing, but I think a deeper discussion on that can be used as a precedent on this aspect. But in the face of this, what you see is the Philippines and a Duterte who want to outrightly reject this internationalism of justice. And he's already done it with the ICC. So the ASEAN in some sense could also be divided on its appreciation of such a mechanism. But let me also share what I found most exciting and thought provoking is the Arab Tribunal, and I think that some sense ties in with the GCC model as well. And if there is some sort of economic development tied in with human rights, I think this could be quite a powerful source. And even this article talks about this intercourse between these two things. So I would like to hear Professor on these points.
Thank you very much. Well, I may sound somewhat biased, but it's because I really like the idea of regional institutions. In a certain sense, I am really biased about, in a positive sense, about regional institutions. Certainly, international law ideally is universal. We have universal treaties operating in various areas, including in the areas of humanitarian law and human rights law. However, international human rights law itself provides for the concept of cultural relativism. So it is understood in international human rights law that well, we have universal human rights, but there can be nuances in their application varying from region to region because of cultural differences. And so I'm quite a fan of regional institutions creating regional international law with due regard to regional challenges and with the ability to produce regional solutions. As far as Asian institutions of criminal justice are concerned, such as the extraordinary chambers in the courts of Cambodia or the other institutions for Bangladesh, for East Timor, for Lebanon, etc., there the formal legal reasons for their establishment were clear. The International Criminal Court did not have jurisdiction in all those contexts because the ICC statute just entered into force on the 1st of July 2002 and did not have jurisdiction with respect to developments which had taken place before its entry into force. But more than that, regional institutions, including human rights institutions, well, they have distinct advantages as compared to universal ones. Those institutions have a better understanding of regional challenges, of regional politics. Very often, the officials in those institutions, well, they will speak the same languages, they will have the same mentality, they will have been trained at the same law schools, and so they will share common approaches to legal developments and to legal solutions. So I believe that there's a big potential for regional institutions in Asia, not necessarily to replace universal developments. No, if states feel like joining worldwide developments and worldwide institutions such as the International Criminal Court, although it's not yet worldwide, but potentially it could be. So they can do so, but regional solutions are more efficient because they're quicker, they're easier to accomplish, they're geographically closer to everyone concerned. They're geographically more accessible for everyone concerned. Like one would not have to fly to Geneva or to Strasbourg in order to have his or her case heard, but simply geographical distances would be closer, and hopefully processes would also be quicker. Therefore, yes, I assume that Asia has a big potential to solve many of its issues, including in the humanitarian field, locally or regionally.
Thank you, Sergey. Can I just add a few words on this? I'm absolutely in agreement with you that regional organizations do play a role, and I want to simply exemplify from my experience two such examples. And one is with Myanmar and ASEAN. In my, well, not extensive, but I had some experience with Myanmar human rights issues back 15, 20 years ago. And particularly when Cyclone Nargis hit Myanmar in 2008, and a lot of international assistance was offered to Myanmar, but the government at the time, the military government, refused to accept foreign assistance, and that was seen as anti-humanitarian. Effectively refusing foreign assistance in time of natural disaster is quite peculiar, because that's a natural disaster. It has nothing to do with any criticism of human rights or democracy and all of that. But nevertheless, the government in Myanmar at the time felt that this is another form of intervention in its domestic affairs, and so on. So the United Nations humanitarian efforts could not achieve much. However, ASEAN, offering also humanitarian assistance to Myanmar at the time, did achieve what the United Nations could not achieve. So being a member of a small organization like ASEAN with 9 neighbors, let's put it this way, actually did work much better than if someone from America, from United States or England comes over and try to do the work. And in a similar way, we have several stories in Africa in the same way, where, for example, Robert Mugabe in Zimbabwe, or former President Bashir of Sudan, were much more willing to listen decisions from African Union other than when the United Nations tried to impact the situation in those African countries. So regions really do play a role. It's kind of much easier to refuse to the United Nations and blame this is a global interventionist, American-led, conspiratorial, or whatever you may think of. But when your neighbors talk in Africa or in ASEAN, that voice you cannot simply dismiss and see this is a global neo-colonialism and interventionism, and blame the Americans and the United Nations for all of those issues. So I think your approach, Sergey, to create regional bodies to impact regimes such as those I mentioned could be a very, very good model forward. Thank you.
And just to add to that point, with respect to these perspectives and neo-colonialist approach which might be adopted, this is what happened at the time of Milosevic in Serbia when NATO bombed, and the 12 perspective was it was an infringement of sovereignty. But the problem, the other front, at least to my mind, would be that there would perhaps be, if there is a distribution of legislation and jurisprudence, there would be a fragmentation. The fragmentation of these standards of international law and also their understanding, which is why perhaps an inter-American code works, or at least works in some sense. Now, I request Megha, who's actually worked on fragmentation of international law, to just shed light on this project, because this is something that she's worked on heavily. Megha?
Well, fragmentation is a danger, but if managed properly, it can be useful. We already have fragmentation, and in a certain sense, international law is based, it takes into account the reality of fragmentation. There are several international courts and tribunals. All of them are formally independent. All of them formally have jurisdictions of their own. The decisions made by all those tribunals are formally binding only in specific disputes and upon the parties of those disputes. So fragmentation is there. The danger is about not allowing fragmentation to harm the system as a whole. But as long as those individual judicial organs do their job, as long as they help resolve specific disputes and as long as they share their experiences with one another, then I would say that fragmentation is, well, at least it's not harmful. It's a reality of international politics. It's a reality of international law. And if we manage it properly, we can live with it.
Just to drive the point home, if you juxtapose the Asian model to the European model, let us also remember that the European model started as a economic cooperation, or it started on the economic front, and the charter really comes out of that. So should that sort of approach also be kept in mind, that only if you become a member of the European Council, rather the other way around, only if you sign the European Convention on Human Rights will your membership to the council be granted. So that sort of a bargain deal must be made. So should this also be given an importance in the Asian model?
Or if you allow me to broaden your reflection, normative developments should go hand in hand with institutional developments. So be it in Europe, be it in the Americas, or be it in Africa, these two elements, they go hand in hand. There are regional human rights instruments, so be it the European or the American Conventions on Human Rights and the African Charter, but there are also institutional mechanisms which enforce those treaties. In Asia, however, the institutional element is lacking. So we have some regional cooperation among Arab states. We have the Arab League. We have ASEAN. We have we have some cooperation in the former Soviet Union, so in the Commonwealth of Independent States, but we do not have yet a Central Asian Union, which I mentioned in my presentation. This idea has been there for a couple of decades already, but the Central Asian Union has not yet materialized. And there are no other workable sub-regional institutional initiatives in the Asian region that would be able to enforce the rules, even if the rules were put in place. So the task for sub-regional groupings in Asia, as I would call them, or sub-regions, is to institutionalize themselves, that is, to formalize their sub-regional relations by establishing institutional mechanisms, and at the same time to develop regional human rights instruments that would be enforceable by those sub-regional organizations. This is my suggestion.
Professor, there's one question which I would like to ask. How do you suggest the synergy between individualism and societal values? For example, European system works on individual rights, whereas Asian system works more on the regional, on the cooperative system or the societal values. So the focus here is more on economic, social, cultural rights, whereas in Europe it's civil and political rights. So how do you propose to make a synergy or to bring a balance in this both differing approaches?
Thank you for this excellent question. And this is one of the cases which I mentioned at the very beginning of my presentation, that I do not have a ready answer. But of course, I fully share your perspective, and I am positive that Asian human rights developments must take into account Asian mentalities in the respective parts of Asia. It is true that unlike Europe, so unlike European societies, Asian societies are more collectivist. In Asia, societal values, collective values are valued, so they are appreciated. And in drafting any Asian human rights instruments, these societal values, which are distinct from European or Western individualism, they should be taken into account. And of course, now at this very moment, I cannot offer any precise formulations, but I do share the spirit of your question, and I could not agree more with you to the effect that Asian human rights law, so if it ever came into being, should be collectivist, and I would even say that it would be beautiful by virtue of its collectivism. Thank you for this excellent question. I fully share your sentiment.
Thank you. Thank you so much.
I do also invite others to share their questions. Professor Popovski, are there any reflections which you would like to offer? Or should I should also invite our dear friends and co-students who would like to participate in the discussion. Very nice to hear from them as well and their perspective on what Professor has presented.
May I ask? I think usually my students always ask me these days.
We do have a question, Prof. We do have a question from.
Let me also ask one, and we will hear the other one. A lot of my students these days ask me about Afghanistan a lot, and I'm not an expert on Afghanistan, I must say. So if Professor Sayapin would like to reflect briefly on what is going on there, is there any first-hand knowledge from where you are in Central Asia about Afghanistan and how people in, let's say, Uzbekistan, Tajikistan think about this conflict as well? It's not a very, I think, relevant to the topic of today's discussion because, yes, it's, we cannot talk about any cooperation with the Taliban regime now. But anyway, if there are some ideas in the Central Asian republics about what happens in Afghanistan, how that can be dealt with in the near future, please, welcome to share.
Thank you very much for this question, sir. I'm not an expert on Afghanistan either, but of course we all follow developments in that country every day with much interest because it's a neighboring country, and we all understand that the security situation in Afghanistan will have an impact upon its neighbors. Well, some of the recent developments, of course, caused concern in Central Asia. One of the questions of law that Central Asian governments must be asking themselves now is like how to build relations with the Taliban in the near future. I'm not sure if they're asking themselves the question about recognizing the Taliban in any form. This I don't know. There are no reports about this in the mass media. But of course, what the mass media do report is are the practicalities of interacting of continued interaction with Afghanistan. For instance, a few weeks ago, it became public that Uzbekistan had been maintaining contact with Afghanistan for the past 2 years. So this was not public information until recently, but it became such just a couple of weeks ago, and the president of Uzbekistan commented about this in approximately the following terms, like, I will negotiate with anyone for the sake of the peace of my nation, and this position is of course understandable. Uzbekistan must be finding itself quite under pressure now because quite a lot of members of Afghanistan's military fled to Uzbekistan, and they're seeking refuge either in Uzbekistan or in a third country. and recently it was reported that they would be transferred to an American military base in Qatar. So on the one hand, Uzbekistan gave them temporary refuge for a few days, but on the other hand, it does not want to keep these people on its territory. I suppose, well, first and foremost, in order not to irritate the Taliban in Afghanistan by doing so, but and also to avoid the responsibility for the maintenance of these people, for providing them with living necessities, etc., etc. Because we're talking about a substantial number of people. The government of Kazakhstan also announced a few days ago that Kazakhstan would not accept refugees from Afghanistan, because society is quite alarmed at this. There were questions in the public domain whether or not Kazakhstan would allow any refugees from Afghanistan, and of course many people were against that because they are afraid of people of a different culture, people coming from a society which which has lived through a lengthy war, and who knows, maybe with genuine refugees, some dangerous people might come to the country. So all those concerns, they exist in Kazakhstani society, and some of those concerns are certainly legitimate. So this is. Let me give you another example. It has been reported in the mass media that the Taliban allegedly, wants to maintain good relations with, especially with China and Russia. These two countries were mentioned by name. The Taliban also congratulated Uzbekistan on the 30th anniversary of its independence a few days ago, and that was a clear political signal that Uzbekistan is recognized as an important regional actor and one of Afghanistan's closest neighbors. So let's wait and see. In any event, the security situation is changing. The Central Asian governments are taking the security threat coming from Afghanistan very seriously. The armed forces of Kazakhstan have been placed on high alert. Again, a few days ago, the annual recruitment campaign began in Kazakhstan, and it was announced that that the government would this year recruit more young people into the armed forces than in the previous years. It was not said plainly that this measure was related with Afghanistan, but I guess the reason is obvious. So the countries in the region are taking serious security measures, and of course they continue observing the developments in Afghanistan. This is what I'm seeing.
Worrying signs indeed. Let me invite Daniel to ask his question now.
Yes, thank you very much. First of all, I'd like to thank Dr. Sayapin for such an informative performance. So my question is, as far as I understood, the International Committee of the Red Cross is the only international organization or non-governmental organization on the territory of the Central Asia trying to promote the international human rights in some ways through the humanitarian help and humanitarian support. So is the case that ICRC fighting alone on this battlefield cannot just win the fight? So what's the probability, what's the chance of appearance of other non-governmental organizations or international organizations which are going to become the bridge for the establishment of the human rights in the region of Central Asia.
Thank you. Daniil is one of my students in my public international law course in this semester, and Daniil will talk more about the International Committee of the Red Cross in 2 weeks' time. But for the purpose of this discussion, let me say a few things. First, I hope I made it clear in my presentation, the ICRC is not a human rights institution. So it is very distinct from organizations such as Amnesty International or Human Rights Watch or other human rights organizations. And the ICRC is very, pays a lot of attention to not being confused with human rights institutions. Because human rights institutions do campaigning, they do human rights advocacy, they rally people, their working method is publicity, and they've always been that way. The ICRC does not work that way. So the ICRC's working method is confidentiality. It works through bilateral dialogue with its partners, be it governments, be it non-state actors, be it other international organizations. So the ICRC maintains confidential dialogue on most aspects of its work, and only publicizes the results of its work. There's even a formula, a rule at the ICRC, like we say what we do, but we don't say what we see. And this is the very basis of the ICRC's work. Of course, by its nature, because the ICRC works in armed conflicts, in situations of violence, the ICRC comes across a lot of very sensitive information, a lot of which has military value. And in order to remain credible in its relations with all partners, so the ICRC commits itself to confidentiality and to not disclosing any of that information which it comes across. And so to the core of your question, the ICRC does not deal with human rights as such, as I said. So the ICRC still does not bear any institutional responsibility for the invocation or promotion of human rights law, because it's not a human rights organization. But within the framework of its humanitarian mandate, the ICRC can invoke some human rights and only a limited range of human rights, which I mentioned in my presentation. For instance, it does not deal with political rights, such as the right to elect or to be elected, or freedom of expression, or it does not deal with economic or social or cultural rights as such, because these are not included within its humanitarian mandate. The ICRC will make a selective use of human rights, and only in those situations where it deems appropriate for the protection and for rendering better protection or better assistance to the vulnerable populations. And so, on the final aspect of your question, you said the ICRC is sort of a lone soldier on the battlefield. This is true. In many contexts, it is so, but precisely because the ICRC works privately and confidentially with its partners, the ICRC often is the only organization, the only international institution in a context of violence or armed conflict, because the other ones will be gone. either because they do not have the necessary expertise or because they do not have the necessary local contacts, or because they are not trusted by the authorities in power. So the ICRC's the basis of trust that the ICRC enjoys worldwide is this very principle of confidentiality that I am repeatedly referring to. So the ICRC will often be the only serious international actor in a situation of violence because it has the trust of its partners. And this is also important. The ICRC very consciously prefers to work alone or with the other organizations belonging to the International Red Cross or Red Crescent movement. Why? Because the International Committee of the Red Cross does not want to compromise its unique identity. It does not want to be confused with the political agenda, for example, of the United Nations. It does not want to be confused with the campaigning agenda of human rights organizations. So this is also why it often works alone. And the result of this is that the ICRC, of course, has limited resources. It cannot solve all the problems in the world. Well, I said in the presentation a few minutes ago that a month ago, the Director General of the ICRC said openly that the ICRC was lacking almost 50% of the necessary budget in Afghanistan. So the ICRC has limited resources and it cannot solve all the problems, but it can solve some. And without the presence of the ICRC in contexts like Afghanistan, the situation would be even more difficult. So this is how it works in reality.
Thank you.
Professor, it's been a riveting experience hearing from you and your expert thoughts. I don't see any further questions, so let me thank you for sharing your thoughts with us and expressing your viewpoints on an extremely current and hot topic of international law. I give the floor once again back to you to offer final reflections, and then we can close.
Dear colleagues, I can just thank you for your kind invitation. I was very pleased to be your guest, to talk to you. Thank you very much, Professor Popovski. Thank you, Ankit, for being so kind to host me. And also, I hope this will be an opportunity for us to start our fruitful cooperation. So cooperation between our universities, between our schools, and I look forward to our students communicating with you. I look forward, Professor Popovski, to remaining in touch and to being able to meet you one day. Thank you so much.
Thank you also from me, Professor Sergey Sayapin. Definitely we should start with a very serious discussion and exchange an MOU between your law school and our law school, and exchange students, have share lectures, join research, some even student exchanges possibly. We are very willing to do that because we haven't actually had much collaborations with Central Asian universities so far. So it will be indeed a wonderful initiative. We will report to our international office and ask them to cooperate with your international office, and they will do the necessary technical work in exchanging the MOUs, but you and I will then take the academic part of the collaboration and think about joint projects, joint publications, and student exchanges. Thank you very much, Professor.
Indeed. With your permission, I will discuss these perspectives with my dean, and we'll be in touch and continue discussing cooperation in working order. Thank you so much.
Thank you also from me.
Thank you, everyone. Thank you.
Thank you, sir. Grateful. Good evening.
Thank you. Bye-bye.
До свидания.